Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 58, ACTA Rectracta.
This Week in Law is brought to you by Audible. For your free audiobook, visit audiblepodcasts.com/TWiL.
Hi, this is Denise Howell, and welcome to TWiL, This Week in Law, episode 58. We're here today with two folks from Washington, D.C. who do law and policy, both with public knowledge. The first is Michael Weinberg. Michael, welcome to the show.
Thank you for having me.
Great to have you. And also your colleague, Sherwin C. Is it C, Sherwin?
Yeah, that's right. It's C.
Great.
Thanks for
Sherwin
having me.
C. Oh, pleasure to have you. Thank you so much both for joining us. Also with us is Evan Brown from internetcases.com. Hi, Evan.
Hey, good afternoon. Happy Friday. Thanks for having me back.
Great to have you back. All right, so we've got a lot to discuss today. Much on folks' minds this week has been the Gizmodo suit, which I don't want to hash through in too much detail because it has gotten discussed so much. But there are a couple of sort of new or different angles that I thought we could hit on today that maybe folks haven't thought about or explored yet. So just to give the context of that, for anyone who might be listening to or watching the show who is completely out to lunch on the issue, Gizmodo, the blog that is part of Gawker Media, got their hands on a prototype iPhone, the next generation iPhone 4, I guess it's called, that was left in a bar by an Apple engineer named Gray Powell. And Gray accidentally, or maybe had a few too many or what have you, left his phone. It was picked up by someone who has now been unearthed. I guess that's sort of a new latest development thing. We can talk about that in a second. They found this person who found the phone and wound up selling it to Gizmodo for $5,000 so that they could dissect it and write about it from every conceivable angle. Gizmodo last weekend was subject, actually one of their writers, Jason Chen, was subject to a technology task force coming to his home when he wasn't there with a search warrant, seizing a bunch of his computer equipment in hopes of finding out the identity of the person who sold them the phone, because they are conducting a criminal investigation about receiving stolen property, possibly violations of California's trade secret laws. We're not quite sure, what exactly they're contemplating charging anybody with, but law enforcement is investigating. And this warrant was served, so there's a good deal of question about the validity of the warrant and the ramifications of having a technology task force or any other sort of law enforcement busting down your front door, which they did, not completely destroying, but at least getting through the lock and coming in and taking your stuff. So, Evan, you actually sent us a story from CNN this morning. Why don't you tell us a bit about this masked person who found the iPhone and what they're saying?
It's a 21-year-old guy named Brian Hogan, and I'm just kind of reading on a couple of things here. This is in a story on CNN.com, and it was actually put through by Wired. 21-year-old guy, Brian Hogan from Redwood City, California, and he's been speaking a lot through his lawyer, which is a criminal defense lawyer from K&L Gates, I think, in San Francisco, Jeffrey Bornstein. And Bornstein's been talking quite a bit, surprisingly. And what I think is most interesting about what Bornstein is saying on behalf of his client here is really saying, my guy made a mistake. The article ends here, says he made a mistake. He should have just immediately turned that phone in. So I find this actually kind of surprising that defense counsel would would go ahead and say that there's probably some larger strategy in saying that, it's somehow trying to deflect blame. But it's interesting to see a lawyer talking as much as what he is here on behalf of this guy, because here's really his client is the one where the most focus on criminal liability is going to lie, whether or not he did the right thing by taking the phone from the bar, and whether he did enough to ascertain where it was, who it was that lost it. Did he do enough to get it back to Apple, and all of that stuff? So that's the newest thing here that we saw this morning, and clearly a lot of this is going to rise and fall as to dealing with what this 21-year-old guy from California who actually found the phone in the bar. A lot of it's going to rise and fall. The questions of liability, and then the corresponding or the subsequent actions and the reasonableness of everything that went on, what Chen did, what law enforcement did, what Apple did, is all going to relate to the reasonableness of this activity here. So new development here.
Right. So thanks for bringing us up to speed on that. From a policy standpoint, we obviously don't want to encourage people when they find lost items to go around looking for the likeliest media outlet that wants to cover them. Do you think, what's your guess, Evan, since we have already a bet on the table about whether criminal charges are going to be brought against any of the players in this case? What do you think about this guy? Do you think he's going to get to have a wrist slap and go home, or do you think they're going to go after him more aggressively?
I think it's unlikely they're going to go after him too aggressively here. I mean, this is such a fascinating story to us all, because it's one of those where it's easy for reasonable people to see all sides of it. I mean, on one side, we've got Apple, who, we all love, right? And even though they may be perceived and kind of being called to the mat here for being draconian and overreaching and strong-arming when it comes to their confidential information here, we all love Apple at the end of the day. But then, on the other side, we've got relatively sympathetic players in this game, like Gizmodo and the writers there, and this guy, who's even though he's unknown, we've all been in situations where you find something and you're certainly excited about it, and you want to share that information. So we can identify with all of these different things here. We've got to keep it in perspective. Go ahead.
I haven't seen a whole lot of identification with Gizmodo among people who've chimed in and talked about this case.
We like Gizmodo. I mean, it has how many millions of unique visitors per month. It's a popular site, and that's what I'm saying there. I mean, I don't know that anybody's coming up to their defense, from a legal standpoint, but we don't like the fact that the cops are busting into, what's his name, Jason, the actual blogger.
Yes, Jason Chen.
Yeah, we don't like the fact. I mean, if you read the description of when the cops busted down his front door on last Friday, we don't like that. And if we can identify with that happening at our own homes, it really is disconcerting. But at the same time, there's this notion, there really might have been stolen stuff here. So we've got to keep it in a larger perspective here. This is relatively minor when it comes to the efforts of law enforcement. Nobody here is accused of stealing anything all that valuable. When you look at the actual device, this has a lot of just hype around it because of the connotations that are involved here with the technology and the newness of it and everything. So that's why I'm confident that not a whole lot is going to come from this in terms of official law enforcement action or any civil litigation, because really this is just one of those things where people have kind of just gotten out of hand. It's almost like no harm, no foul. If anything, people are going to be more excited about the next generation iPhone. I know I am. I mean, that was a wonderful video on Gizmodo looking, the front-facing camera. I'm going to defer a purchase perhaps now until that actually comes out. So I just think in the end, this is going to be a relatively minor thing on the radar.
Right. The other shoe that is likely to drop, as Tim Brisson told me on Twitter, is that every criminal procedure professor in the United States is probably writing a final exam pattern to include a suspect journalist. So,
right.
Yes, good luck to all you law students out there who are going to have to parse
Yes,
this
and
case.
make sure you study the Zurcher case, because this is I remember reading that in criminal procedure in law school, and then didn't pay it any special attention, but now this is really something to bring it up to our era, to really make the holdings in Zurcher and then the subsequent Federal Privacy Protection Act very relevant to those of us who think along these lines.
Right. Well, the other reason that all this becomes pretty relevant is here we are all sitting here doing some online journalism. I don't know if anybody would consider us journalists under the traditional rubric, but there are a lot of people out there these days who are in the boat. Maybe they don't write for Gizmodo, but they write it or talk or however they disseminate their information about a whole lot of things that they know about and are passionate about. And whether they're going to be entitled to protections that would otherwise apply to journalists is a big question in our country. We have a federal shield law that's been pending or languishing in Congress for some time. And I'm wondering if our folks in D.C., Sherwin and Michael, have any thoughts on the status of that, whether you think it's going anywhere, or whether it's just going to sit there and continue to be picked apart in committee. Michael, any thoughts on that?
I don't have any specific intelligence on where it's going. I think though it is kind of a good example of what happens when sort of internet shakes things up, because a lot of the things that we worry about, sort of copyright or communications policy, that there was a law that existed and then the internet came and it made everything really complicated and threw all the cards up in the air. And the folks that are pushing for this reporter shield law kind of are unfortunate because they didn't get it in before everything got thrown up in the air. So where on a copyright standpoint, we might say, yeah, these are really, really complicated issues, but we have a copyright statute we have to deal with. For the reporter shield law, when we try and decide, who qualifies as a reporter, when is someone actually in the act of reporting, and where are the lines? People say, this is really complicated, and it's really complicated, and we don't have to deal with it if we don't pass this law. So it's sort of stuck in the complicated but don't have to work on it pile, I would suspect. I don't know if Sherwin has any better intelligence than that.
I don't know that I have any specific intelligence on the federal shield law. I do think, speaking for myself, that it is important that we don't want the law to draw too fine a distinction between. We don't want the law to be the one, or a courtroom to be the one to judge, what it considers journalism. I think, that this is a matter of free expression and sharing information with the public, that we don't want to get too cute about drawing bright line rules about how large your circulation has to be for somebody to be a journalist. I think this applies not just in this particular case, but in all sorts of areas. Even if you're talking about Freedom of Information Act filings, what sort of fees the government will charge you and how they deal with your request will also depend a lot of times on whether or not it's considered for a news article or for journalism. And I'd like to think that we can use a broader definition than the old-fashioned idea of a guy with a steno pad and a press card stuck in his hat as being a journalist.
The other thing I think that makes this case sort of resonate with people, or this episode with Gizmodo, is this notion too that, of course, it's always a sensitive issue when someone comes into your home and there's a Fourth Amendment question raised, whether something can be searched and seized. But then I think there's a subtext there too that it is important to a lot of people as well, and that is the fact that data is. I was actually surprised that the police would go into Jason Chen's house if, in fact, what they were looking for were his email communications, et cetera, related to the development of his story. Obviously, they were looking for photographs and other things that might have been more logically stored locally. But I think more and more people are storing things like their email in the cloud. And there's a whole different batch of considerations there when you think about, how someone is going to go after that information. Interestingly, Google just released a Google Maps app that discloses exactly how many government requests for information they're getting from various players out there. So that's something to check out, and we have it in our show notes. If people want to take a look at that, from the U.S., there's something like over 3,000 requests for information to Google over the year, and some 80% of those requests are complied with. And you can see that on a country by country basis, except for China, which they haven't included because China apparently considers that data related to national security, et cetera, and won't let Google release it, or has asked that it not, and Google is complying. So the other consideration that comes up there then is whether the Fourth Amendment has any sort of application in a cloud context. Jason Chen and Gizmodo get the opportunity, if they so choose, to contest the validity of this warrant, because the Fourth Amendment does have some rather stringent requirements about when you can barge into somebody's home and search and seize. Under the laws that protect data stored in the cloud, however, the Fourth Amendment doesn't apply. So just because you've made that decision to store things off-site with some third party, all of a sudden protections that would come into play if it were in your own home can vanish. And there's another interesting piece in our show notes regarding some updates to the law there that are being sought. Let me just find the link to it real quick. Got a lot of links here. Oh my goodness.
It's the one called No Cops in the Cloud.
No Cops in the Cloud. Oh, no wonder I'm going back to...
It's on page 3 of our links.
Right, 1 second here. I'm a little bit lost in my links. There we go. By Leslie Harris. And what's being sought here are some updates to the Electronic Communications Privacy Act. And the major reason for the update request is the distinction between the Fourth Amendment and what you would have to do to get this information from an ISP like Google, as shown in their Google Maps app and all the requests they're disclosing there. All you need is a subpoena. And I'm wondering if our policy folks in Washington, Sherwin, do you have any thoughts on this one?
Well, sure. I mean, there's this movement now, not just with tech companies, but also with civil liberties groups and a lot of other groups. This is ranging from the ACLU to Americans for Tax Reform, the library associations to Google's, EFF and all these other folks. And I think the idea behind this is we want, we want the law to reflect the way people use things, and not just the technicalities of how it's used, right? The machinery shouldn't determine more than the use of it. If it's stored on our hard drive in our house, then that's going to have a sort of protection that it's not going to have in the cloud, because it's stored off-site, because the law recognizes those physical boundaries much more readily than it recognizes the use boundaries, or the difference that it makes to me sitting at my keyboard, whether it's in my hard drive or whether it's on the cloud, is much less significant. And the fact that more and more data, more and more applications are moving to the cloud means that the way that ECPA was framed really does need updating. And I think that's what these principles that all of these different groups are calling for are trying to do. I mean, there's a variety of different ways in which ECPA needs updating, and I think that's one of the key. That's one of the key ways in which they want to see something move forward, because it just doesn't reflect the way we use information, the way we store information today.
Michael, as processes work in Washington, do you think that they have a chance in accomplishing the change that they're seeking here, getting the Electronic Communications Privacy Act updated?
Well, it's always good when you can bring sort of a big, diverse coalition of people together and say, this needs to be changed, and here's how it needs to be changed. So I think they've taken a really good first step in pointing out that this isn't an issue that just Google cares about or just ACLU cares about, but they have this really broad coalition of people who you wouldn't necessarily see on the same side on a lot of issues. And when lawmakers and when policymakers see something like that, where everyone can agree that it's a problem, that's going to get their attention. And it is something that needs attention. I remember I took a class when I was in law school from Oren Kerr, who does a lot of work in this area. And when we got into this stuff, the first day of the section was, let me first describe to you how computing worked 20 years ago, so you can begin to pretend to wrap your mind around how ECPA works. Because this will be, as modern computer users, these distinctions will be meaningless and nonsensical and very confusing. So it's easy to see how you could get a lot of people behind, a very diverse group of people behind a change like this, because it is long overdue.
Right. There's something in it for everyone, seeing some changes made here, because not only do you have, individual interests, the Fourth Amendment concerns about whether or not, an individual's privacy is going to be wrongfully abridged, but you've also got the concerns of industry, making sure that they can comply in a reasonable way. And so one compelling way that regulators and legislators, can and should and indeed are, I don't know are, but you guys in D.C. would know more about what actually is happening. But one basis and one thrust, or one motive for all this, would be to foster the development of infrastructure that's there. Clearly, things are moving to the cloud more and more, and in a couple of years, we're not even going to really be thinking of the distinction probably at all. So bringing the law in line with the technological reality seems to make a lot of sense. Just like similar things that we've seen with the enactment of the DMCA in 1998. That was, in my view, very forward-looking, along with Section 230 in 1996, recognizing that the whole architecture and infrastructure for the way information is communicated required some kind of change in the law. Now, the recognition of differences in ways that data are being stored will necessitate, and I hope, usher in a significant revisiting of this that's going to make a lot of sense for everyone at the table, all of these diverse parties who are under the same tent.
Yep.
Well, go ahead.
Oh, yeah, I'd certainly hope that's true. I mean, and having that diverse coalition probably helps a lot. I mean, I think if you look at the Digital Due Process site, I think one of the things that you'll notice is that they have some broad principles that a lot of people can agree upon. I think the hard part now is trying to actually turn that into legislative text that people will agree upon, and that Congress will vote on favorably. The DMCA process was a long, drawn-out one as well, and even with all of the care and consideration taken into it, I think there's still a number of things with the DMCA that we have some issues with. I mean, there's the notice and takedown provisions, which seem to be working pretty well. Even though there's some questions at the margins. And then there's a whole other question of anti-circumvention provisions, right? The DRM provisions. And whether or not, how forward-looking those are actually is kind of interesting, because there are some ways in which some of those provisions had a particular view of how technology worked, or that wasn't quite as future-proof.
Right.
Yeah,
but
absolutely.
I think we can agree that the DMCA at least was forward-looking in 1998. I mean, that's my take on it. And so the activity that's being done here now, or that should be done, is analogous to that, in as much as it has to face a new reality with the way that technology is actually being used.
Right. When was ECPA enacted?
86,
quite a while ago.
Right? 86, same year as the big tax overhaul, and also another one is in 86 was the Computer Fraud and Abuse Act. So that was a big year for a lot of big changes, and that's another statute that that has seen some transformations over time, but it still contains some vestiges of mid 1980s technology for sure.
So one cloud company that seems to be pushing back on governments getting its user data is Amazon, who now has actually filed suit. It has been embroiled in these disputes now in North Carolina and previously in Colorado. I'm not sure if elsewhere as well, with state governments attempting to obtain information about Amazon purchases so they can make sure that they're collecting enough tax from people, sales tax. So here, North Carolina has made some sweeping requests from its Department of Revenue for some details on nearly 50 million purchases made between 2003 and 2010. Amazon has stopped its affiliate program in that state and also in Colorado as a protest to that. But now they've actually filed suit as well. And they're urging, interestingly enough, that the First Amendment would bar a lot of these disclosures because, in general, purchases of books, DVDs, Blu-ray discs, and other media enjoy special privacy protections, as Declan McCullough has written in his article over at CNET. So I think, that's just sort of an interesting footnote or thing to note in the terms of this getting data from cloud services discussion, that there is the opportunity for these folks to push back, and Amazon is clearly doing that here. Evan, any thoughts on this one?
Yes, but before we jump into this one, let me correct myself. The Computer Fraud and Abuse Act was enacted in 1984 instead of 1986. Oh, wow. I misspoke earlier, and I know that's a huge discrepancy there. So, yes, this whole Amazon thing is really scary, and I'm really happy that they're standing up to North Carolina on this because really. That is huge when the state government is going to get so much information about the predilections and the preferences of Amazon users, because that's so your purchase history on a site like Amazon or service like Amazon.com is so revealing of what it is you're thinking and doing. And there's some case law, perhaps ironically from Colorado, even though Colorado and Amazon are kind of fighting it out right now. There's a Supreme Court case from Colorado in 2002 dealing with the Tattered Cover bookstore, where they didn't want to turn over purchase history. The Tattered Cover is a big bookstore in Denver. Anybody with connections there knows what I'm talking about. They didn't want to turn over the purchase history of what books people had bought here. So this is this is just really frightening, and I really hope to see this one go down a pro-privacy path here. And see this one just kind of headed off at the pass, because that's way overreaching by the North Carolina state government on this one.
Yeah, Michael, is this something that the federal government's just going to keep its mitts off of because it involves state taxation? Or do you think that there might be some federal regulatory role here that would extend to cloud service providers like Amazon?
I think it's generally an issue of state taxation, and it is one of these things where you do recognize that North Carolina is clearly hurting for money, like all the rest of the states are, and whether or not they should be collecting money from Amazon, they certainly did this in a not the smoothest way possible. But I don't know that the federal government is going to step in. There has been, and Sherwin can correct me if I'm wrong, there has been a movement in the federal government to exempt the internet from taxation. And that is an ongoing thing where every couple of years it comes up, and we have to decide if it continues to make sense that we need to foster this tax holiday for the internet or make it permanent, or try and stop it and say this, it's time for these folks to be under some sort of regime. But at the state-to-state level, it's going to be a decision that those states need to decide how they're going to handle it as more commerce shifts online.
Yeah, Sherwin, what about that? And what about these emails that we all get every couple of years that says this, that are sort of the stuff that you look up at Snopes.com, that the federal government is about to start taxing the internet? Is this something that's a reality?
Well, taxing the internet, I'm not, I guess that might be one way of putting it. I think obviously states want to gather sales tax. And buying things online, there are going to be sales taxes in state, and how those are tracked is it's people are going to have varying opinions on where the where the policy lines are on, what should or shouldn't be subject to these sales taxes. I think it's interesting in this particular proceeding that it's not it doesn't seem like it's a specific criminal investigation of any one person or any one company that's evading tax. And that's one of the odd things, I think, about this and some other cases where you'll see somebody trying to get data more for a policy reason than for a specific law enforcement reason. I think we saw something like that several years ago with Google and I believe it was search results.
Right, where they've definitely stepped up and pushed back against certain sweeping government requests for information. And I think this application they've made available is another nice step toward that end of letting people know, if not exactly the substance, at least the identity of their requesters and the volume of the requests and how much is actually being complied with. That's a good bit of transparency to add to the equation. Speaking of transparency, one thing that has recently become publicly available that much hue and cry was happening before that occurred was ACTA. And Sherwin, I understand that ACTA is something that has been on your particular plate lately. Do you want to give us the latest now that we're no longer just looking at leaks? We have the actual draft document in hand, and is it as scary as folks have written, and what are you doing about it specifically?
Sure. Well, as for how scary it is compared to what folks have been saying, it depends on which folks. I think there's been a lot of anxiety about a couple of suggestions that might be in ACTA. I guess the idea of searching iPods at the border and implementing a 3 strikes program. Now,
before we get into the details of that, let's just clarify exactly. We're talking about something called the Anti-Counterfeiting Trade Agreement. And what is this beast exactly? Okay, so it's called the Anti-Counterfeiting Trade Agreement, and it's being negotiated between the United States, Europe, and a handful of other countries, mostly developed countries. And its stated goal is to crack down on counterfeiting. I think the concern is that it's framed much more like a treaty regarding intellectual property law generally than a mere enforcement document. Now, part of the problem with the transparency is that it's not being put forward like a standard treaty where it goes before the legislature and there's going to be a public debate in Congress or in the Senate about it. It's being put forward as a sole executive agreement. Basically, the executive branch just gets to negotiate this agreement with other countries and implement it without further debate in the other branches. That's because they're claiming that it's not going to alter or affect existing U.S. law. And how do you feel about that? It seems to me like there's certainly the opportunity for that to happen.
That's exactly what we're worried about, and I think that's where our concerns lie. Even with the new draft, there's a lot of details in it where I think the claim by the negotiators at the U.S. Trade Representative is that they're coloring within the lines of U.S. law. The problem with U.S. law, especially with copyright law, is that there's a lot beyond just the black letter of the statutes. There's a lot of case law that covers this. For example, the part of ACTA deals with secondary liability, contributory liability, vicarious liability, the sorts of things that we were talking about and developing new doctrines for in cases as recent as 2005 in Grokster. I mean, this is still evolving law. It's not in the statutes. And the treaty, in a sense, is codifying that in ways that might not take into account all the factual situations and the delicate balances that are struck by courts.
So it's hard to color within the lines if you don't know where the lines are?
Basically.
Yeah. So let's get to what you were going to talk about a second ago, this border searches of electronic equipment that you might have on you, things like laptops and iPods and iPads and anything else, and also the 3 strikes component.
Okay, I think these are two of the things that really caught people's attention when we didn't have the text to look at, and you can see where they came from, because one of the big sections on ACTA was on border measures. Now, usually when we're talking about copyright and trademark counterfeits and border measures, we're talking about large shipments of goods. We're talking about the containers full of, I don't know, fake Louis Vuittons or even, fake pharmaceuticals, things like that. I think the anxiety really comes from the fact that we have a whole bunch of provisions in ACTA that are dealing with things that seem to be much more on the consumer level. There's language about, what sorts of criminal liability might attach for smaller offenses. There's talk about ISPs and other sections. So the fact that what we have in front of us isn't just focused on sort of the commercial scale is what's getting people much more nervous about that. Now we see provisions in the release text, and we saw some in the leaked text that I think the negotiators are trying very hard to sort of head off that objection and say, well, okay, look, we'll put in this provision that says that countries can have a de minimis exception for some of these things. I think that might quell some of those specific objections. It might not, because again, the exceptions are optional for the countries to implement, and the penalties or the enforcement provisions are mandatory. The same thing I think is true with 3 strikes. What we've got, and the problem, and we have statements from the negotiators, from U.S. Trade Representative, I think some out of Europe as well, insisting, look, we're not going to have a mandatory 3 strikes provision. We're not going to require every country that signs on to ACTA to have a law that requires an ISP to kick you off if you're accused of infringement a few times. And that reassurance is fine. It's just that what we're worried about is not just a legal mandate. It's also having these governments encourage a particular technological solution to a very specific problem that's a narrow part of what the agreement is supposed to be trying to address, and one that has all sorts of problems associated with it. I don't want to go on too long. There's all sorts of...
No, let me see if I can focus this a bit. First of all, Jay in the chat room has said that a border search of a laptop is equivalent of a mind probe. And I think he's got an excellent point there, that, there's a whole lot more information that would be captured by that search than any sort of IP potential infringement search would be after. And I'm wondering if ACTA has any built-in safeguard for that sort of thing. And also, if you know off the top of your head, since this is something people ask on the show all the time, are you required under ACTA or any other applicable law that you know of today, if you have your data encrypted on a device, to also help the law enforcement people decrypt what's going on there?
As for decryption, I have to say I need to go back and take another look at it. Now,
I know EFF has a great page on that, so if people are looking for specific answers on that front, that's where I always point them. But I think the answer is maybe. You might have to help them.
On the decryption,
the
answer is going to be definitely maybe. The actual searching at the border is, you actually don't have a lot of Fourth Amendment rights at the border, which is a big problem. So what ACTA does for this, that's why I think, the border provisions as regards copyright stuff, it's certainly not for public knowledge. That's not where the action is. What we've been paying a lot of attention, and we'll probably, as it's been out for about a week, so we've been looking at individual pieces one at a time. For us, a lot of the questions really are in the internet section, where we are talking about things like how liable are ISPs, and what sort of activities are going to make somebody a secondary infringer. I think part of the problem is we have laws in the U.S. and the USTR is saying, well, we're not going to do anything in ACTA that's going to contradict any of the laws in the U.S. In Europe, they have their own sets of laws operating on a fairly different legal model. And their negotiators and the Commission are insisting to the European Parliament and to their constituencies, nothing we do is going to change anything in European law, in the European acquis of IP law. And there's a massive disconnect there because somebody's either going to have to give and have said something, have made a promise they can't keep, or ACTA needs to be a lot less specific than it is right now.
Right, and it seems like the danger is if you've got this trade agreement out there that countries can sign on to, and they have these various check boxes of options they can decide to include or not, that they might just rubber stamp it, in toto and take the whole thing in, not pay too much attention, decide that this is what's been put out there, and so must be a good idea, and we're off to the races. Is that a big concern?
Oh, definitely. I think it's been pretty explicit that even though this is an agreement between just a few countries, mostly developed countries, right? The U.S., EU, Australia, Canada, Switzerland, and so on, that it's intended that once all these parties come to an agreement on ACTA, that they're going to try and get other countries to sign on to it using trade pressure or other things like that, saying, join up on ACTA, or we'll provide more free trade, lower tariffs, etc. So I think it's definitely aimed at these other countries, and the idea is that since it's not just on enforcement procedures, you're going to be changing the laws of these other countries with more required liabilities and without exporting the extremely strong exceptions and limitations that we have in U.S. law.
Mm-hmm. So let's talk about the criminal liability aspect, since we've already talked on this show about how once you've got a criminal investigation going, this triggers some rather more severe consequences on the part of the person or persons being investigated, such as we saw in the Gizmodo case. In fact, at EFF, Corin McSherry has a good editorial up there that wonders whether the Gizmodo raid is a preview of Hollywood's dystopian plan for copyright enforcement. And the thrust of her argument there is, if you are going to classify something as a criminal activity rather than something that would simply be a civil violation, which would result in damages if you infringed, for example, if you've got the whole body of criminal law behind you and criminal procedure, then you've got a rather big stick as law enforcement. And is this a big concern with ACTA, both for the ISPs and for individuals?
Well, there are definitely provisions in ACTA that that certainly in a lot of countries would extend criminal liability to things that that they don't currently have criminal liability for. And yeah, I think that the blurring of that distinction is something that is troubling. To analogize a little bit, there was a post recently on Boing Boing about how I think a representative of the International Phonographic Federation industry was saying something. The headline read, "Representative loves child porn," and that was a direct paraphrase, because what he said was, we really like child porn because it serves as a great example, as a great sort of wedge to get this idea of illegal content and the need of extreme measures to combat that illegal content. And the problem with that, of course, is that not only is it an appeal to emotion, but the majority of what you want to deal with in child porn is going to be a criminal prosecution and not a civil action. I think the reverse would be true of a lot of online copyright infringement. It's really mostly at the civil level. And the measures you take, with one are really not equivalent to the other. I mean, let alone sort of the heinousness, the level of heinousness we're talking about. Kicking down a door to find a file share, it just seems a bit excessive.
I'm wondering, and by presenting this question, I'm not necessarily espousing a certain position on this, although I think I do have a position on this. Why is it, or more precisely, where is the origin of our thinking in drawing this distinction between civil liability and criminal liability, and how appropriate, why is it that we think that civil liability is generally more appropriate to handle copyright infringement than criminal enforcement? I mean, one of the things that I frequently bring up is the misnomer of calling copyright infringement something in the nature of content theft, because I think of it more in terms of trespass. But even though there is a distinction in those comparisons, trespass is in the nature of criminal activity. So, if I'm going to, for example, trespass on someone else's property, I can be criminally liable for that. They don't have to sue me, but the prosecutor will take care of that. Why is it that we find it so offensive, this essential notion that copyright should not be treated as a criminal activity, except perhaps in very, very narrow circumstances? Good
policy question. Sherwin, any thoughts?
Yeah, sure. I mean, I think a lot of it has to do with how much civil, a civil liability deals with the protection of private rights versus a public policy question, right? In the case of trespass, usually, it's not going to become a criminal issue until unless you want to really engage on that larger public policy question.
Or if you happen to know the county sheriff, then it can be.
Right. So, I mean, we do have criminal liability for copyright infringement, unlike other jurisdictions, but we definitely have that, and it becomes a policy question of when do we want to use government resources to protect private rights. When it rises to that level of doing enough damage to the law, to the structure of that it really warrants that pursuing it.
Right. This is obviously it's an interesting question, and I think that's why we're exploring it. And one of the thoughts that I had when I read the post on by EFF, I think it was Corinne McSherry, right? Talking about the Gizmodo raid as a preview of this awful state that we'll be in here. I mean, both sides of the dispute here go over the top and do a little bit of disservice to their positions. I mean, as much as I love the EFF and the things they stand for, it's saying that going over the top in some of the things that they say here does a little bit of disservice, just as big content does by overusing the word theft and things like that. So there's got to be a middle ground here. But what gives me a little bit of discord in my thinking here, or some discord that I recognize, and it's kind of the basis for what the question that I posed a little bit before, is going on to that very precise question that you posed there, Sherwin, as when does it become appropriate for government resources to be used to enforce private interests? And a useful comparison that I made in my mind when thinking about this in reading about it was comparing it to civil rights. The EFF article, Corinne McSherry's article there, talks about how awful it is to have the FBI investigating and having federal law enforcement doing the investigating and the enforcement of copyright law. But, we're not going to say, and one of the other points she made in saying why that's bad is because, the content industry is doing better than ever, reaping substantial profits, historically better than they've ever been doing before. Let's compare this to civil rights. I mean, we're not going to say that it would be wrong for the National Guard, let's say, a government resource, yes, it's at the state level, but okay, let's still use it. It's still okay for this comparison. Nobody would say that it would be wrong for the National Guard to show up and make sure that there is peace and order at a civil rights demonstration, right? Even though the civil rights movement, obviously, this is the overstatement of the century, saying that the civil rights movement has seen tremendous advancements and that, we're probably in a better state today than what we've ever been in terms of civil rights and equality and all that stuff. Why is it okay to say that naturally the National Guard should show up if for example, we get word that the Ku Klux Klan is going to be clashing with some civil rights demonstrators on the town square. Where is that point?
Well, where's the private interest there?
The private interest is in the individual's civil rights, the civil liberties that are granted to each individual under the Constitution.
Right. So you're comparing those sorts of liberties with the commercial interest in protecting your creative works under the Copyright Act. I think,
not just the Copyright Act, but the Constitution. It's a constitutional right that I have to have the exclusive right to do these things with my works.
Well, I mean, I would think that the comparison, I mean, it's a pretty extreme comparison, and I think the reason you have the National Guard there is because you're concerned about public order, you're concerned about public safety, potential rioting, physical harm, mayhem and death. And preventing all of that. I think, again, I'm not saying that, that we should eliminate criminal liability, but I think that, that some of those public policy considerations really should apply in terms of what IP enforcement rises to the level of criminal. And
we're talking about somebody's bottom line as opposed to somebody's bottom in a hospital bed. So,
right, but it's their bottom line that they have a constitutional right to pursue.
Mm-hmm.
I feel like I'm coming across as being aggressive in my position here. I don't even know really what I think about it. It's just the issues that I see arising here, and as to have meaningful discussion on it. It just seems like there's a real gray area that as thinking people we need to give some consideration to.
Yep, I think that's entirely true, and I'd agree. I mean, it's something that needs thought and deliberation. But I think just because something is it's the public policy questions of how you enforce something, even a constitutional right, have a lot to do with the facts of the situation. It's not that you don't bring out the National Guard for every constitutional violation. Oftentimes, oftentimes a Section 1983 suit will do just fine.
Right. Yes. Good point.
So before we leave the ACTA discussion, I do want to talk about the 3 strikes aspect, Sherwin, and just kind of get your thoughts, because we're talking about penalties that apply once you've gone through a criminal or civil infringement action, and we've discussed this previously on the show that every time one of these 3 strikes regimes goes into effect, it somewhat takes that legal process out of the picture. First of all, what are you at Public Knowledge doing about that, other than, I guess your role is just to increase knowledge about what that exactly will mean, and then how does that lead to any sort of ability to affect what's going to ultimately be enacted here?
Well, I think what we're trying to do at Public Knowledge, is let people know what's going on, not just in the public, but also to let policymakers, legislators, people in the federal agencies know sort of what's at stake with these different regimes. Now, I think there's a lot of debate and sometimes some confusion about what a 3 strikes regime would mean, and some people are calling existing systems we have here 3 strikes. People will point to something like Section 512I of the DMCA and say, well, that's a 3 strikes regime because it says, something to the effect of, basically that online service providers can, in appropriate circumstances, terminate the accounts of repeat infringers. The problem with that, if the difference between that, what we have in the law now, and the 3 strike system as it's being proposed and implemented in places like France, is that there we're talking about somebody who's actually been found liable legally in a court of being an infringer. We're not trying to shortcut that system through an administrative process, or even implement it in just through a private negotiation between a content holder and the ISP.
The other
Right.
thing.
Sorry, go ahead.
Just the other thing about three strikes to remember is that at the end of the road, however you get there, if you say it's three accusations or three accusations, one of which has to be a conviction or whatever you do, at the end of the day, we do need to think back from a policy standpoint how important internet connectivity is and what kind of behavior should allow you to be kicked off the internet in its entirety. Because internet connectivity is no longer sort of a luxury or something. Being able to be online is critical to almost everything that you would do every day and will become more so in the future. So, I mean, I could commit all sorts of horrible crimes with my phone. I could do all sorts of banking fraud. I could call in some guys to rough somebody up, and I'd go to jail and I'd be punished for that behavior. But when I got out, I'd probably still be able to use a phone. And if I'm using my computer to infringe on someone's copyright and I'm caught, I should pay the penalty for those copyright infringements. But then to say you are kicked off the internet, sort of the medium for communication of the modern age, because you were convicted of these other things, is something that we really need to be wary of and to think very carefully what can trigger that sort of rejection from society.
Yeah, that's an excellent point. And I think one of the big, hairy, scary things about ACTA is that it would spread that sort of regime to places that don't now have it.
I do want to be clear about three strikes and ACTA that, I don't think that the USTR or anyone else is lying when they say that there's no mandated three strikes in it. But yeah, I mean, the question of whether ACTA would encourage this sort of thing, there is language in it that suggests that says that countries shouldn't stand in the way of agreements like three strikes. It's bracketed language. It's something that's being negotiated. But one of the reasons that we were especially worried about this early on is there's language like that, and there's language that looks a lot like what we've got in 512I, and how that gets interpreted as these things get reconciled can look a lot like three strikes, especially when we see people looking at our current law and saying, well, we can sort of tweak it a little bit, and suddenly we've got a three strikes provision there. So that sort of hybridization of having sort of the worst of both worlds in terms of enforcement is what we're worried about. Exporting, having sort of an asymmetric export of enforcement without the protections and the limitations and exceptions that should go along with it.
Right. But isn't there, now I'm getting into an area that I know very little about, this whole international treaty negotiation world. Isn't there a treaty out there that does export our DMCA to other countries as well?
Well, the DMCA itself is actually the result of the WIPO Internet treaties. But the DMCA goes way farther than the WIPO treaties does on a number of aspects. It has protections for access controls, which aren't internationally required. And it has bans on marketing or selling circumvention provisions that aren't required in the WIPO agreements. Now, there are also other bilateral agreements between the U.S. and individual other countries that have a lot of the sorts of provisions that are in ACTA. Usually these are these massive documents consisting of dozens of chapters about agriculture and machining and auto imports, and there will be an IP section in it, and it'll have some of these IP policies in it. The fact that these have happened doesn't mean that we're particularly happy about those provisions either. But here's the first time that we're seeing a sort of a plurilateral agreement between a variety of different countries specifically focused on IP alone and IP policy alone.
Right.
Sherwin,
What about the safe harbor provisions of the DMCA? Do they get any international play, or are they unique to our country? And does ACTA do anything about that?
Well, I mean, there's there's parallels to the safe harbor provisions in EU law, for example. And I think you have two different sorts of regimes and very different ways of, you have different ways of dealing with it that have been sort of put into the draft text of ACTA. So some of that's in there. And again, the language doesn't always track exactly, and there's always multiple versions of things. So there is some question as to how those are applying and how well they track.
Evan, I'm sorry, I cut you off.
I was just going to make some smart comment. I was going to ask Sherwin why he failed to mention the protection of the registration for vessel hull designs under the DMCA.
That's true. I completely forgot that one.
Right.
But, actually, I'm
love to know the legislative history of that.
Not to go off on a completely, another tangent of something that's a little bit scary about ACTA, but, we have a lot of provisions in there about statutory damages, actual damages, how they're calculated, and so on. And they're following the model of a lot of copyright damages, how they might be calculated in some places, or some theories about how they might be calculated in others. But what we also have in the negotiations is some people trying to apply this not just to copyrights, but also to trademarks, to patents, to, I don't know if vessel hull designs are specifically mentioned, but to all the various types of IP mentioned in TRIPS. And that includes like geographical indicators, things that don't have that same sort of level of recognition here in the U.S.
Right.
Right. Okay, well, we've got a whole lot more to get to, including our tip of the week, our resource of the week, and lots more stories involving Facebook and Comcast and net neutrality and all sorts of good stuff. But before we get to all that, I need to thank our sponsor, Audible. Audible.com is your spot on the internet for all things audio entertainment. They have podcasts, they have books, as we used to say, books on tape, like some of these antiquated statutes that we've been discussing. Books are no longer on tape, and they are on audible.com if you want to hear them read by some really talented readers. And the selection is just enormous. More than 75,000 downloadable titles across all types of literature, including fiction, nonfiction, and periodicals. For listeners of TWiL, Audible's offering a free audiobook to give you a chance to try out their service. You go to audiblepodcast.com/TWiL. It'll have all the details of the offer and how you get your free book. The recommendation for a book that I wanted to give you today is one that I picked out both because I'm reading it and think it's really good, and also because the reviews on Audible are dismal. And so I'm hoping that someone will read it and like it as much as I am enjoying it, and will help rectify that. It's called The Whale. It's The Whale in Search of the Giants of the Sea. It's by Philip Hoare, narrated by Michael Page. And much like here on TWiL, where we get pretty passionate about some obscure kind of issues and can stick with them and go off on tangents, that's kind of what Philip does here in his book, The Whale. He's clearly very, very engaged in the sea and in thinking about the sea and its various denizens. I figured in honor of our recently passed Earth Day here, this would be a great recommendation. I really am enjoying it. He incorporates a lot of literary references, stories from his own life about what the sea has meant to him, and explores what's going on with the state of whales in the world today. Here, poor Philip has gotten 2 one-star reviews on this book in Audible.
You can rescue him from obscurity now.
Yes,
yeah, and it wasn't Merlin Mann that reviewed it, was it? Giving him the one-star reviews.
Not Merlin. So I must say I'm enjoying this book, and I hope that you will do. Check it out on Audible, audiblepodcast.com/TWiL. Audible_com is how you can follow them on Twitter and get a lot more recommendations and ideas about other things to download and try. Thank you so much, Audible. We love your support. And good luck, Philip, with getting some better reviews there on Audible. Hey, speaking of reviews, we do check out the reviews of TWiL on iTunes. And I noticed this morning that the last one was posted up there on February 20th. So we could definitely do with some more up-to-date reviews. If anybody likes the show or doesn't like the show and wants to give us some feedback, go over there to iTunes and give us your thoughts. Now, before we get into more substance here, I wanted to get to our tip of the week. And that is, those come my way. There's actually a couple of them from the Project VRM mailing list, which I follow along with great interest. These are folks trying to do all sorts of good things, like make sure that the customer responsiveness that you get is something that's actually under your control, that you control your data. And one little thread that was going on over there in the last week or so were some announcements by Elliot Noss at Hover. He is the CEO of 2Cows and has also founded this service, Hover, which has all kinds of interesting things that it'll do: URL shortening, email with personalized domains, such as I use denise.howell.net, thanks to them. All sorts of great stuff over at Hover. And what's new over at Hover is that they have announced no-wait customer service. So all those phone trees that you sit on hold and have to push 6 and 2 and 5 to get to a live person, there is no-wait customer service over there at Hover, which we like a great deal. And then Michael O'Connor Clark, also from the VRM list, pointed out that they do that too over at FreshBooks. FreshBooks is based in Canada, and they're an online billing and bookkeeping company. And in fact, he said, not only do we have no-wait customer service, but we all take turns answering the phone. So you could either wind up talking with Michael himself, or you could wind up talking with their CEO if you have a customer service question. So I like that approach, and wanted to highlight those two things as our resource of the week: actual people answering customer service calls. And finally, on that note, wanted to give a plug to the group at Project VRM and congratulate them on the current issue of CRM magazine, which is all about vendor relationship management as opposed to customer relationship management. In other words, switching that dynamic around so that the customer is in charge. There is an online digital copy of the magazine where you use your mouse to turn the pages. It's at, I did a tiny URL for it, is.gd/BKWAE, and that will bring you to the current edition of CRM magazine. Manifestos or conversations, big article about the Clue Train manifesto. It's not your relationship to manage. All sorts of good things on the new behavior of the social customer, etc., and being in control of your data and how it's used. Check that out at CRM Magazine. So let's get into talking about something else that's real important from a policy standpoint. It's something that Reporters Without Borders had published a list of the worst possible countries for various violations of internet freedoms. The U.S. is not on one of those lists, but the U.S. doesn't exactly get a clean bill of health either. One of the things that was called out is something we talked about before, the absence of the federal shield law. The other thing is our struggling with the net neutrality issue. And recently, we've had the FCC get its wrist slapped in trying to expand its net neutrality policies through this Comcast BitTorrent case. Michael, you want to tell us what's going on the net neutrality front, and whether the FCC is now walking away like a puppy with its tail between its legs, or how is it going to now tackle its attempt to ensure that we have net neutrality?
Well, I certainly hope that they don't walk away with like a puppy with its tail between its legs, because net neutrality is important, and I think the FCC is right in thinking that it is an important thing and worth investing some time in doing. So right now everyone is trying to figure out how to deal with the case that came down last month, the FCC versus Comcast. And the short version of that case is that the the authority that the FCC claimed it was using to implement its net neutrality rules, the DC Circuit decided that was not, that authority didn't exist, and they couldn't do that anymore. So they kind of gave the FCC implicitly a couple of options. The authority that the FCC thought they were using for the net neutrality was called ancillary authority under Title I of the Communications Act. And basically what that is, the theory of that is that the FCC, if it doesn't have a specific mandate from Congress to do something, and Congress has not passed a huge FCC can be a cop on the beat for the internet bill. So if the FCC can find something that Congress has given it a specific mandate to do, and if the next thing they want to do is ancillary, is sort of a logical extension of a specific mandate from Congress, then the FCC is allowed to do that. And the court found that the statutes that the FCC was pointing to ground their ancillary authority were not adequate to do what they wanted to do with net neutrality, to impose network neutrality rules. So the FCC sort of has three options. The first option is to try and find another piece, another place, another statute that they can ground their ancillary authority. And that's problematic for two reasons. The first reason is the court did a pretty good job of marching through the logical places to look and systematically swatting them down. And the other thing is that the FCC wants to be involved with the internet for things beyond network neutrality. They're worried about things like universal service and making sure everyone has access to broadband. They're worried about, in an emergency, being able to prioritize emergency information over the internet, over IP-based communications. And if it tried to find a specific hook for each one of those things under ancillary authority, it would essentially have to find a different statute for everything it's worried about, and then it would be challenged, and it'd have to take each one of those pieces to court. So from our standpoint, that's not a great idea. The other option is to go to Congress and say, hey, Congress, it's time for you to pass a law that says FCC jurisdiction extends to the internet, so it can be a cop on the beat when something goes horribly wrong, when someone is blocking content or redirecting a search bar or something like that. There's someone that's allowed to step in. And that may be a long-term strategy, but there's not a lot of stuff moving through Congress right now. I don't think anyone thinks that it's possible to get it done quickly. And while Congress doesn't do it, if FCC just waits, then there's essentially, as I said, no cop on the beat on the internet. So if something goes horribly wrong, nobody can step in. The third option, and the one that we have been pushing, is to reclassify broadband internet access as a Title II service. And that would bring the internet well within the jurisdiction of the FCC, and it would say, this is something that we can easily do. We don't have to find a specific mandate for every policy that we want to secure on the internet. We can just call it all Title II. And
Title II is telecommunications?
Sorry, of the Telecommunications Act.
Yeah.
And it's what's traditionally been used to regulate things like telephones and other sort of voice and standard communications.
So it's not broadcast?
It's not broadcast. No, it's not broadcast television or anything like that. It's the telecommunications part of the Communications Act.
And it doesn't fall there now, the internet. Where does it fall now?
Well, that's a good question. A month and a half ago, I would have said it's under Title I. Now it is not so much. It's sort of unclear where it lives right now, because the FCC is clearly working on the problem, but the FCC has not advanced a new theory yet. So it's in this limbo. And what that really means is, right now, if tomorrow an ISP decided to start blocking content, or an ISP decided that they wanted to redirect all your searches to their brand search engine, there would really be nowhere for you to go and complain about it, especially if you are someone who has one choice or maybe two choices of ISPs. You don't really have the option to leave your ISP. You couldn't go to the FCC or anyone in the government and say, well, you need to step in and tell them to stop, because they would say, well, we don't know that we can right now.
Right.
So that's why it's so important that the FCC make a decision soon.
Hey, Michael, I can't remember if this was something that you said earlier in our conversation or if this was on one of the videos that's on Public Knowledge's website, which are terrific, by the way, those little informative videos. But I learned somewhere from you that the predicament that we're in now with the FCC's jurisdiction over the internet being out there in limbo somewhere or in purgatory or whatever, is kind of the FCC's own doing, reclassifying it into Title I, taking it out of Title II. Is that right? Did I hear you correctly? Whenever that was something that the FCC had done earlier. If so, I'm curious about that to learn a little bit more about what the FCC may have done to make the bed that it has to lie in now.
Right. So the FCC in the mid 2000s, they made a decision that they basically were examining broadband internet access, and without getting too technical, what they decided was, really, when you buy something from an ISP, you're sort of buying a combination of two things. You are buying the ability to move your bits from your computer to the internet and the bits from the internet to your computer. And you're also buying email access from that ISP and web hosting and DNS and a home page. And again, this is sort of ISPs of 2003, 2004, 2005. And so they said, those services are all more than the simple transport of bits from place to place. Those would not necessarily fall under Title II. And so what they did is they said, because all these things are so intermixed, we're not going to divide this service anymore. We're just going to say it's all one service, and it's all under Title. We're going to pull everything out of Title II and say everything is Title I. Everything is kind of dominated by the email access and the web hosting and the DNS. And the transport stuff is part of that, but it's so intertwined we can't divide it. And so we're going to push it all into Title I. So they put themselves in a position where and we're going to use ancillary authority to still govern the internet the way that we need to govern it. And so what you had was the FCC making a decision that they were putting it in Title I, but that was a safe decision because they had ancillary authority. So it was problematic for other reasons, but at least was under the umbrella of what the FCC could control. The problem now is that their ancillary authority, the rug was pulled out from under them, and so they have to make this decision. The funny thing, looking at it from now, is when I don't know how you guys see this, but when I think of my ISP, I happen to have Comcast. The thing that I care about that Comcast is doing is that moving of bits, making sure that I'm connected to the internet. I know that somewhere out there in the internet, there is a Comcast email account attached to my account that I could use if I wanted to. There's probably some sort of web hosting that if I wanted to put up a web page at michaelweinberg.comcast.net, they would allow me to do, and I appreciate that. But
you do care about those things? I get the feeling not too many people care about those things. But
right,
go on.
As a novelty, perhaps.
Right. I'm sure there's somebody. I'm sure people care. There is someone out there who cares about it. But our sense, and I think this is accurate, is that people look to their ISPs to connect into the internet, and all the rest of it is kind of gravy. And so what we're telling the FCC is to kind of recognize that reality, recognize that people see broadband internet access as sort of a transport service. Nobody's asking their ISP to do much besides move the bits onto the internet, and that's the kind of thing that falls traditionally very logically into this Title II regulatory box, where the FCC could say, we aren't regulating the email and the web hosting and the DNS and all these things. All we're regulating is the transport component of internet access, the moving of bits around. That's all we're really worried about. Everything else can exist and go on doing what it's doing, but we're gonna step in and make sure that the transport part works the right way.
Right. Is there a danger that if the FCC does that and another challenge comes up and winds up in front of a federal circuit court, say the DC circuit, that a court is going to find that too cute by half, that they've just decided, oh, well, it was Title I and now we're going to go hang our hat on Title II because we want to have this authority and we think we arguably have a basis for it here, but we recognize, we've switched gears. Is that going to be a problem for them?
I think there's two parts to that. I think classifying the transport element as Title II is a pretty safe bet. So the real question is, can they change their mind? And the Supreme Court decision that people think about as sort of solidifying the original Title I ancillary authority decision is this Brand X decision. And the Brand X decision is oftentimes cited as saying that it's okay to have, or that the FCC is right to put broadband internet access in Title I. If you read the decision closely, what it actually says, it's actually kind of a boring administrative law case, not a fancy internet case. And what it's looking for, what it really says is that the FCC has a lot of discretion, and it's an expert agency, so its job is to look at all the evidence before it and make a decision. And if it decides to make that decision, that's great. And if it decides to change that decision, it doesn't actually need to find evidence that it was wrong before. What it needs to find is evidence that it can be right now. So if it can base its decision to move everything into Title II in real evidence, which we think is a fairly straightforward thing, then it shouldn't be a problem. And again, it's weird that it moves sort of out of interesting internet law and into administrative law, which is not necessarily as interesting to everyone. But it turns on.
Couldn't the Obama administration help this process by encouraging legislation that would actually put net neutrality out of an agency's bailiwick and onto the laws of the land? Aren't we just sort of struggling along here because there's really, Evan was being throttled in one of our previous episodes. It was falling off Skype right and left. For sure, his ISP was behind it. And if we wanted to gather evidence and by the way, I'm kidding. If we wanted to gather evidence and launch an attack, yes, or launch a challenge on that, I mean, we really have. There's no legal basis for doing it, right? Because net neutrality is this great policy principle that is part of the broadband plan and all, but there's really no enforcement mechanism if we leave the FCC out of the picture. Is that accurate?
Well, the FCC, if the FCC classifies broadband internet access under Title II, it would then have the jurisdiction to make its network neutrality rules the law of the land. But you're right. The other way to do it would be to go through Congress, and the practical problems with going through Congress are that Congress is not necessarily a fast-moving body. So while long term it might make sense for Congress to step in and think about that, to see it as a solution to the immediate problem of there being no way to stop bad behavior by ISPs on the internet because the FCC hasn't classified yet is a little bit problematic, because if we sit around waiting for Congress to act, it may be a little while before that happens. I mean, it would be great if tomorrow Congress stepped in and passed a law and this was all a done deal. It was very straightforward. But I think that may be one of those things that's great, but might not happen anytime soon.
I think, especially in an election year, and when we've got signature legislation on such broad issues like financial reform and immigration, on the docket, that's going to be kind of a tall order. But
yeah,
I also
do you guys ever feel like the sort of poor stepchildren in Washington D.C. because you're working on these issues that are not necessarily high on the legislative agenda?
Well, no, I mean. It's not going to be the most signature issue of it's not going to be the thing that's on the news every night, but it's there, it's important, people recognize that, and that's fine. One of the things I did want to point out about sort of the authority that the FCC has, it's really, I mean, Congress gives the FCC the authority to over interstate communications by wire or radio, and that's more than broad enough to include the internet. The reason that it doesn't include the internet and telecommunications right now is just because of a decision made by the FCC, 8 years ago. So all they have to do is take a look back at that decision and reclassify, as Michael said. So it's not that there's this gaping hole in the FCC's statutory authority. It's the way in which they implement that statutory authority in the regulations that leaves that hole, which I think the Comcast decision highlighted.
Well, that is good to know. Thank you for enlightening us there. Michael, you want to tell us about our freedom to text?
So freedom to text is something that we have been working a lot on here at PK, and actually a lot recently. It's the most recent story that's come out was last month. A charity called Catholic Relief Services was trying to raise money for Haitian earthquake victims. And they received word from one of the wireless carriers, from Sprint, that they were going to cut off their text message program because it didn't comply with some of the rules that Sprint had laid down. And that was the latest and most public in a string of problems that people trying to use text messaging have run into. One of the earlier ones was NARAL, Pro-Choice America, about 2.5 years ago. They had set up a text messaging program where people could sign up and they would receive alerts from NARAL when something important was happening, when they should call their congressman or woman. And Verizon cut them off because they found it to be objectionable content. And these two incidents kind of highlight a problem right now, that the text messaging is sort of this unregulated wild, wild west, where the carriers exert a lot of control in a way that is not very transparent and can be even arbitrary or impenetrable for a lot of people. There's no free speech on text messaging, and people who try and set up businesses around text messaging or political campaigns or other issues, they run into long problems, a lot of roadblocks, and they sort of live in fear of having the rug pulled out from under them. And this is another, I hesitate to say, it's another FCC regulatory issue, where actually, unlike the internet, where there was a regulatory classification and it was moved into a different box and we're trying to maybe move to another box again, text messages have never been regulated by the FCC, and it's sort of a historical accident. When the last time the laws were really redone in 1996, there was no text messaging, and at this point, no one has gotten around to, at the FCC, to explain exactly what happened. So just as where right now, if you were being blocked on the internet, there's nowhere to go because the FCC can't step in. Right now, if you have a business that uses text messaging and you wake up one morning and it's been completely cut off, or you're using text messaging for your nonprofit or for some sort of political organization, and you wake up one morning with an email in your inbox that says, "Sorry, you've been cut off," there's nothing you can do. There's nowhere you can go to say, "Well, wait, this is crazy. I didn't break any rules. They didn't explain to me what I did. And now I have hundreds or thousands or hundreds of thousands of people who have been relying on my program, or I have a business lined up to do this, and now we're just off." So what we're trying to do is say to the FCC, this has been an oversight, and it's time for you guys to step in and do a very straightforward thing, which is to say, this is how we view text messaging. If you have a problem with text messaging, here's who you come to, and here's how we'll handle it. And that's what we're doing right now. So what we're trying to do is highlight to policymakers and decision makers that text messaging is actually important. I mean, I was in a meeting earlier today where someone said, I hope that we reach a point sometime in the near future where some policymakers don't sort of pride themselves on how foreign technology is to them. And what we're trying to do...
They do pride themselves on that?
Yeah, I mean, sometimes you'll go into a meeting, or there'll be a congressional hearing, and somebody will begin their questioning with, I don't even use a fill in the blank, and I certainly with text messaging, but even I don't use a BlackBerry, I don't use this, I don't use that, and there was a study that came out 2 weeks ago that American teenagers a huge percentage of them send hundreds of text messages every couple of days, and to recognize that just like phone calls, text messages are sort of this platform for communication, and we shouldn't let wireless carriers who aren't necessarily acting under any sort of malice, but for a variety of business reasons, are very reluctant to carry some things and not others. We should make sure that a platform for communication is open for communication, and
Right.
just like phone calls are. And so that's
Right.
what we're trying to do with that campaign.
So
You
is there
know-
something that people can go to at Public Knowledge to further that cause?
Definitely, I think it's in the show notes. We have a text messaging issue page where you can go to learn more about what we're doing, and also is a very simple form to sort of click on and type in your contact information. Just tell the FCC text messaging is important, and you should make sure that it's protected and open to everybody when they
Right,
need
but
it.
just like with the telephone, I mean, obviously you don't want your carrier telling you what sort of phone call you can or cannot make, but you might want your carrier getting involved, or perhaps the government more appropriately getting involved, as they have, setting up do not call lists and the like, with making sure that you're not bothered using that technology, that you're not getting phone spam. And I think that text spam would be certainly a concern. Is that folded into your activities and how this is being viewed?
Oh, certainly. I mean, nobody wants to turn text messages into just nothing but spam. And there's just with telephone numbers, there are ways to set up do not call lists, and there are steps that carriers can take to reduce spam and to make it so spam doesn't happen. What we're just trying to say is those steps that they take, if you think that they've overstepped their bounds, that they've been overly protective, or if they've been cutting people off in a way that doesn't make sense, there's somewhere for you to go that will hear your case. You don't just have to go back to the carriers and say, your decision was wrong, and they will say, well, actually, we made this decision, and we have no reason to change it, so this is what it's going to be. We're trying to set up a way to work with the carriers and with the legitimate concerns of carriers and people who use text messages, both like you and I use text messages, and businesses and organizations that use text messages, to say, let's work together and make sure there are guidelines that protect everyone's interests, but also make sure that those guidelines aren't so overly protective of one group's interests that it sort of crushes the rights of another group.
Well, that sounds like a good approach. Couple of quick things to touch on. First is just since we're focusing on things happening in Washington, D.C. today, one of the obvious big lawmakers there is the U.S. Supreme Court agreed this last week to decide the constitutionality of a California law that seeks to ban the sale of violent video games to minors. Two lower courts have struck down that law as unconstitutional based on the argument that it restricts speech. So we'll have to watch and see what happens there. Also, Evan, I put this one in the show notes for you. There's a pretty fun article in there about coming up with a policy position on how we're going to govern our robot friends, robot rules. This
Sherwin
one
loves
from
this too.
from the ABA Journal, because robots aren't just computers. They're obviously things that have the ability to act in the real world. That is, if
Right.
they get beyond where they are now. Sherwin, you want to weigh in on this one?
Oh, I'm sorry. I just thought I saw it in the notes, and I thought it was awesome because just it has those overtones of the robot uprising. But
Yes.
I don't know. Evan probably might have more to say on this. But my thinking was, I understand that there's one set of rules or one set of doctrines that have developed around software liability, and then there's another set around products liability. And honestly, if you're putting out a product that has software in it, that doesn't automatically shove you into this other category. I mean, if you have faulty software and you're liable for that software, but not necessarily, what it might do with data. On the other hand, if you're the one who put that faulty software into a machine that is capable of doing damage, if you're the one who put the buggy software into a robot lawnmower that has blades, well, that's, I would say that you've got a problem there, and that might well be on the manufacturer who linked those two things, the the ineffective software and the all too effective blades together.
Right, and the other wrinkle in all of this is that in the case of software and computers, the EULAs, which have been found to be pretty universally enforceable, even though they're also pretty one-sided, are very good at protecting the manufacturers from liability, and the extent to which that would translate into a world where robots are running around as computers that can move and act.
This is all great, because no matter where we go in this, the path before us is laden with a bunch of really interesting issues. Not only when we're in the first in the near future, where we're talking about these issues of products liability and whether or not there should be vicarious liability for the the person who sets the robot free out into the environment and all that stuff. But where I love thinking about all this stuff, and it gets kind of really out there, is when the artificial intelligence advances to such a state that these machines become conscious, and then thinking about then if with consciousness, then do they have rights? And if they have rights, then they naturally should have obligations. So it will really be an exciting day in jurisprudence when a court holds that a non-biological computing substrate is responsible as an agent out there in our legal system. That'll be a real turning point, even more grand than the singularity itself.
It's going to be an interesting day when we can have a robot that can do that, whether or not the jurisprudence backs it up. If I see a robot that can chase me around because it wants to, I'd be a little worried.
Yes,
right.
Maybe it can seize your computer equipment, find out where you got that unreleased iPhone.
Oh yeah.
Yeah. Okay, we've got a couple of updates from the chat room. Number one, Sherwin, in tribute to the coolness of your name, all the folks in the chat room are now changing their nicknames to Sherwin nickname.
Okay, that's flattering, I guess. I mean,
a little honor for you. And also, Sherwin Virgil. Sherwin Virgil in our chat room has sent along some breaking news. Did you guys see? You remember way back during the campaign when Sarah Palin's email account was hacked?
Oh yeah, that kid in Tennessee.
Yeah. So he's been convicted. The 22-year-old former Tennessee college student has been convicted of 2 charges of hacking.
His dad is a state representative, right? In the state legislature there in Tennessee. So that's pretty interesting.
No, I haven't been following the case, but apparently there has now been a conviction, and I assume it's under. He was not found guilty of wire fraud, and nothing
Computer Fraud
on
and Abuse Act, wasn't it?
Yeah, that's what I was going to say. It's unauthorized access to a computer and obstruction of justice. So
it's filed under it was a good idea at the time, maybe,
right.
But not such a good idea anymore.
Right, exactly.
And Denise, it surprises me. I figured you'd be all over this case, because you seem like the kind to be all things Sarah Palin. So.
Oh, do I now?
Actually, not.
No, I was a huge fan of some of the folks who were impersonating Sarah Palin back when it was fairly topical to be doing that, not just SNL writer and wonderful comedian and 30 Rock. What's her name?
Tina Fey.
Yeah, Tina Fey, not just her. But there were some great folks on YouTube and stuff before Tina Fey got into the act. Yes, indeed. Okay, so let's see here. Michael, you had an interesting thing in your Twitter stream I thought we would just bring up, because I loved your commentary, which said that you'd never met anyone who loved their set-top box. And there was something going on that could ban set-top boxes as we know them. You want to elaborate on that for us?
Yeah, sure. This is actually another thing that we've been spending a lot of time on, and my colleague John Bergmeyer has been spending a lot of time on. So in 1996, Congress passed a law that one of the purposes of it was to introduce competition into set-top boxes. And the dream in 1996 was that you'd be able to walk into any Best Buy or Circuit City or whatever was kicking around at the time and buy any number of boxes that you could use to tap into your cable. And that hasn't really worked out. TiVo is a great example of a company that has done that, but they're more or less alone. Them and a smaller company called Moxie are the only ones running around. And there are a lot of reasons for that. A lot of it has to do with cable card and the way that it was implemented. But the FCC, having now recognized that this is a problem, is starting to talk about this new device that they're calling the AllVid. And we were calling it the Gateway for a while, but I think AllVid is a much better name. And in the abstract, conceptually, what it would do is your cable, or now your satellite, or your Fios, or your UVerse, or whatever you have would plug into it on one side, and on the other side, an IP stream of your TV, of TV signals would come out. And pretty much any device you wanted, hopefully, will be able to plug into that IP stream, and you could watch TV on it. So that means that you'd have a, kind of like a cable-ready TV again, which is now lost to history. Mm-hmm. Or you could buy a set-top box, and maybe a set-top box that, you had an app for cable, and you had an app for Netflix, you had an app for Twit TV, and you had an app for all sorts of things. And it would be one box that could do it all, because a box that can run TV that can render TV is a box that can render TV, and you could maybe do your Facebook and your Twitter and all those things. And cable companies would be free to also provide an option for set-top box. But as a consumer, you could decide, if you weren't super happy with your cable provider set-top box, you can move on somewhere else, and it would hopefully open it up to a lot of innovation. So that's
right.
The dream.
Because when I read your comment that nobody loves their set-top box, I thought about the set-top boxes I do love, and none of them have anything to do with cable. Well, obviously there's TiVo, and that's one exception. But say something like the Roku or the Apple TV. Let's see, I can't think of any others off the top of my head right now, but the things that are bringing in content that have nothing to do with cable in creative ways. And so you're saying there would be the ability to incorporate cable into that kind of a business model?
Yeah, that's the hope. And I mean, if you think about it, you can walk into a bar, any bar in America, and you'll hear people talking about how much they love their phones, or how much they love their new computer, or their iPad, or their Roku box, or anything. But you don't hear people say, "I got this great DVR from my cable company yesterday. You won't believe how awesome it is."
No, you don't hear that.
And so the hope is that by making it easy to plug a consumer electronics device into cable, and by cable I mean cable and satellite and Fios and UVerse and all those things, by doing that, you could really open up innovation. Because right now, as you mentioned, there's sort of two tracks of innovation. There's the cable innovation, which is your cable box, and then there's the other box innovation, which are the Rokus and the pop boxes and the whatever else of the world.
I guess Boxy just came out with their own one. Mm-hmm.
Right, the Boxy box, which are doing these incredible things. And you look at it and you say, if it can do all of these things, why not add cable too? And so that's the goal of this AllVid program.
And where does Sling come into all this? I don't have one of those, and I understand people love them. They do interact with your cable, right?
Yeah, Sling actually is now owned by Dish now, but Sling is slightly different only because Sling sort of takes what you have and moves it somewhere else. And so you could certainly, there would be no reason why you wouldn't be able to plug something, or at least in the abstract as is being discussed right now, plug your Sling box in and be able to use it like you could use a Sling box now, which is access everything you can at home when you're on the road or at work or all these places. It would move it like anything else. So a Sling-like product could be integrated into your existing box. There's no reason from an engineering standpoint why your Roku box that also supports cable couldn't also have a Sling app built into it.
What is the impediment? Why haven't Roku and Boxy and everybody else incorporated cable already? What is the impediment to their doing so now?
Well, right now, the way you plug into cable is with cable card, and anyone who has a TiVo has a little bit of experience with that. Cable card doesn't work very well. It only works. It has a number of problems. One of which is it's only a downstream receptor, so you can't do things like on demand. And in order to work with cable card, you have to be certified by Cable Labs, which is controlled by the cable industry. And by that I mean just the cable industry, not the other groups. And so the certification process is incredibly arduous. And the sort of the weird fluky thing that holds a lot of this stuff back, as it turns out, is the control of your on-screen guide. There's a lot of fighting over who gets to decide what your menu looks like and your guide looks like, and what, when you move from piece to piece, what that is. There's a lot of fighting going on over, when this is implemented, who gets to offer on-screen guide options and how they work out. It's one of these tiny detail things that is maybe surprising to hear about outside of Washington, but there's been a lot of time and money spent fighting about on-screen guide control.
Huh. Yeah, because for a long time, though, one of the things I loved most about using my TiVo was that the guide was so much nicer than what was offered by the actual cable box.
Because the TiVo had to make a nice guide in order for you to want to buy it.
Right.
So there was a competitive reason to work on it.
So they're one of these sort of favored nations kind of situations where they've gotten through all the approvals, but it's not so easy for anyone else to do that. Is what you're saying?
Yeah, TiVo has spent an incredible amount of time and money and effort getting approved. But for a lot of companies, I mean, Steve Jobs has said this about Apple TV. Mm-hmm. They aren't touching cable because it's not worth it. It's this huge amount of effort to be able to deliver to customers sort of a not quite complete version of the cable that they're already paying for. And so it's a lot of effort with this not much return. And really, as a customer, if I'm paying for cable, if I'm paying for cable completely, I should really be able to watch it how I please.
Right. Should be like your electrical service coming into your home. How you use it is up to you.
Right.
So let's talk, since we're talking about TV, let's talk about what's lurking between the television channels that I didn't know about until you brought me up to speed on this, Michael. There is white space there. There's spectrum there that could be used for mobile devices. What are you guys working on that front?
This is really based in the digital TV transition a year or two ago, when the nation switched from broadcasting in analog TV to digital TV, which is why you can now get over-the-air HD with surround sound and all these things. It needed much less spectrum to broadcast. Digital is much more efficient than analog in broadcasting, like in almost everything else. And so, whereas a lot of spectrum had been allocated to TV channels to make sure that they could broadcast their channel clearly all over, they needed much less spectrum all of a sudden when they switched to digital. So the question was, what are we going to do with all this spectrum? Because not all spectrum is created equal. And TV spectrum, not surprisingly, is really good at broadcasting long distances and going through buildings and going through obstructions. So it was incredibly valuable spectrum. So the hope was that some of that would be set aside for what's called the TV white spaces, and it would be sort of like a Wi-Fi on steroids. I mean, right now, a lot of us have wireless routers in our offices or at home, and my wireless router is great, except for the fact that it works within they say 300 feet. It's probably more like 100 feet, and you run into problems if you have walls and things. And part of that is a function of the spectrum that it's using is not great spectrum. It's good spectrum, but it's not great spectrum. So the idea is if we can open up a Wi-Fi-like environment with some of the TV spectrum, then all of a sudden the kind of connectivity that you get on a smaller scale for a Wi-Fi hotspot could stretch over miles, and you could cover all sorts of areas. You could use it to bring broadband to rural areas where you can't build out fiber. You could use it in the city to connect all sorts of devices and have sort of medium distance uses for it. And just like Wi-Fi, there are things that people would think of to use it where at the time it wouldn't have occurred to anyone.
So is this something where the infrastructure is there because the cable infrastructure is there, or how would this actually propagate itself out?
Well, you would need equipment that is that would be white spaces equipment. And there are a lot of developers, Microsoft and Dell, and a bunch of people have mocked up prototypes and are kind of waiting to bring this stuff to market. But it would be like Wi-Fi, where you'd have kind of a base station and you'd have receivers that would be able to talk to each other using this white spaces.
Mm-hmm. And who would operate the base station?
Well, it would depend. I mean, if consumers could get their hands on it, then consumers would. The point of it would be that you wouldn't need a license for it in the same way that you need it for like a cell tower. So it would be this open, free space where people could just could develop as is. And because of the way the radios work, they listen then talk. So they would listen for an open space and then broadcast on that space, changing dynamically, which allows you to get a lot more data into spectrum than if you have to just block things off in case someone's going to be broadcasting for it.
How are the speeds? How would the speeds be? How would the speeds be?
Well, for the devices, they are broadband speeds. I mean, the part of it is an engineering issue as to what you put the specs, but the important thing about it is that just like when wireless first came out, it was wireless B, and then it was wireless G, and now we're sort of moving into wireless N, where the speeds get better and better. So the thing that the engineers worry about in the long term is more of its propagation, its ability to spread, and that's where this TV white space, a lot of times it's called the beachfront property of spectrum, because it's the area that has great propagation. It can go through buildings, it can go long distances, so you can just use it to reach all sorts of places that you can't do right now, and you could do it on an unlicensed basis, which means that if I have a great idea for a white spaces device, I don't need to go spend $2 billion to secure the spectrum at the FCC. I can just build to these specs and do it.
Right. So what's the stumbling block here? That the spectrum has not been released for this purpose yet by the FCC, and is there opposition to what you're describing?
There are two stumbling blocks. One of the stumbling blocks is there are of all things actually, there are wireless microphones that were operating actually illegally in some of this space that are now trying to be protected. So a lot of houses of worship and the NFL and Broadway and all these places that you would think of use wireless mics are concerned that if people start using these white spaces devices, all their microphones are going to stop working. So there's been a lot of work of figuring out how to sort of accommodate these people and make sure that every mega church in the country doesn't lose its microphones, which is being done.
I keep seeing Madonna Blonde Ambition tour.
Right. Exactly. But then you would only see Madonna. You wouldn't hear her because her microphone might not. And the other problem is that there was a discussion around the National Broadband Plan about trying to maybe repack the TV stations in a way that would free up even more of the spectrum. So move some of the TV stations around and maybe take away some of their broadcast spectrum and reallocate it to the internet. So right now, if you use an aerial antenna to get HD TV, network TV, which actually I do, not only do you get NBC and ABC, but you also get a couple of sub-channels that right now the broadcasters aren't necessarily making the best use of. One of them will usually be like a weather map that's just sort of always there, and one of them will be reruns of 70s sitcoms. And so the thought is maybe you could take some of that spectrum and use it for broadband internet. But the problem is, as you start repacking the channels, you can, if you don't do it right, you can squeeze out those white spaces. And so part of is, as the FCC starts thinking about, and they certainly haven't decided they're going to do it, but as they start thinking about repacking television channels, it's really important to make sure they remember to keep the white spaces. And so we kind of have a problem because there's been a little bit of a slow process getting the white spaces live. And until they go live, people don't realize how awesome white spaces could be. So it's easier to sort of pack them away so we never see them. So the hope is that we can get the white spaces devices out in the real world soon enough, because as soon as they're out there, people are going to say, this is incredible. This is like everything I always wished Wi-Fi was and more.
Great. So how can people work toward that?
Right now, I wish I had a single place to go. Right now right now there's not an easy way for people to say white spaces are important to me. They can keep their eye on our policy blog at our website, publicknowledge.org/blog, and we try and keep people updated or follow us on Twitter and updated about all of our issues. And when there is time that will be effective for people to tell the FCC and their representatives, white spaces matter to me. I want this awesome super Wi-Fi. It will be really great for them to then be able to be aware of that and catch that. But right now we don't have an active. There's not an active place to weigh in on it. So I would just say stay tuned, because hopefully white spaces are coming.
Good. That's really informative. Thanks so much for letting us know about that. That was a total new one on me. So let's have you, Michael, give us our resource of the week. You had emailed me with something that you thought might be interesting that involves getting RSS feeds of federal information.
I felt bad sending this to you. I felt it's so old. It's so old to everyone but the federal government. It's like, this is email is my tip of the week. It's this great resource that you can use to communicate with people.
Sometimes we forget.
But the federal government has slowly but surely caught up with the internet age in some places and better in others. And this is what we use all the time to track the things the federal government is doing. There is a website called fedthread.org that will take the Federal Register, which is the sort of official record of what the federal government is doing, and parses it all in XML and lets you search it by agency or by keyword or anything else you might want. But importantly for us, you can then save those searches as an RSS feed. So every morning I come in and I have an RSS feed of all of the things that the FCC did release that morning. And it's all squared away in my RSS reader, and I know it's there, and it's easy for me to deal with. And also for the FCC dockets that we care about, the FCC.gov has set up in its ECFS system, the electronic
comment filing system.
Right? Yes, 2.0, updated from its 1.0, which was rolled out in 1997, I believe. You can also search by docket and then get an RSS feed. It's not as user-friendly as I wish it was, but if you go to our website, you can often find what the docket numbers are. So if you care about white spaces, if you care about text messaging, if you care about the other issues, you can tell the FCC, basically set up an RSS feed, and every time anyone files anything in one of those dockets, you get a copy of it. So if we're worrying about text messaging and Sprint or Verizon or a nonprofit that's been injured files, it pops up immediately and we know that it happened. And, as a small organization without a lot of time to just sort of keep watch over things that might be changing, the RSS revolution is here at Public Knowledge.
It's wonderful news. Now, it might be a little bit inside baseball to folks who aren't lawyers, but yes, keeping track of dockets is a big part of what we do to see, who has filed what in what action. And I know, Evan, how is it there in Illinois? Do you any of your courts have RSS feeds for their dockets yet? Do you still just go and click refresh for all your cases?
Illinois State Court is way behind, but I was actually thinking about chiming in, so I'm glad you brought it up, so I can say this. I'm happy to say that the Seventh Circuit Court of Appeals has been.
Ooh.
I think we may have just had Evan get throttled. Oh no!
Oh no!
We'll have to start.
Seventh Circuit's not happy with him.
Marshalling our evidence there. John, if you could get back in.
It must have been something that I said about the Illinois State Courts.
Yeah.
Maybe the judges are.
There you are.
You're back. Good. Okay, well, I think we can hear you, but your video's frozen. Can you say anything, Evan?
Yes, I'm here. I was thinking that maybe it was. Do I sound all right? I'm looking weird to myself.
No.
The Seventh Circuit Court of Appeals has been making opinions available by an RSS feed since 2006, and actually the recordings of oral arguments have been available I guess you'd call it a podcast for about that long. So the federal courts here, not too much on the district court level here with the opinions. I rely on Justia's service a lot that queries the ECF database, and I guess it's the ECF database to be notified of new filings at the district court level. So we're all right here in Illinois.
Great. Well, Sherwin and Michael, I was sad to see that you guys got passed over for this position, but apparently the White House has itself a law blogger. So we'll just go ahead and congratulate PI lawyer and blogger Eric Turkowitz, who, as was reported on the Volokh conspiracy and other places, has been anointed the White House's official law blogger. I don't think he has begun his tenure as that yet, but if you want to get an early jump on things, he's on Twitter at Turkowitz. Let's see, did I spell that out somewhere? I think it's TURKEWITZ, something like that. Eric Turkowitz, yes, TURKEWITZ, at Turkowitz on Twitter. You can have some dialogue with the White House's official law blogger to be. Anybody have any thoughts on whether the White House needs a law blogger or anyone reads the existing White House blog? I mean, it was sort of revolutionary when they rolled it out, but is it having any kind of impact there in Washington? Michael and Sherwin? Sherwin first.
I actually have to say I haven't checked back on it on the White House blog recently, and I don't know what larger effects there might be for the law blog. I mean, what is nice about it though is, I mean, law blogs do seem to have their own particular sort of role in the blogosphere and also in legal writing spheres, because I think they fill a really nice niche in between people publishing formal articles or even just, notes or comments in a journal and, sending emails to lists to something a little bit more public. And you get some really interesting debates on a lot of them. And I can't see this as being anything but a good thing. At absolute worst, it's harmless. And at the best, it could be, a really interesting way to see people engage, I think, a little less formally with some interesting legal ideas.
Right. Michael, you going to add that one to your reader?
Yeah, we'll see. I mean, I think Sherwin's right. It's either good or nothing. It certainly isn't bad. I know the FCC actually had there are problems with how official the blog is and what counts as a submission and things like that. But I think for someone at the White House, it's great to explain things in probably a less formal but still very informed way. So if people want that level of detail, it'll be a great resource for them.
Cool. Evan, longtime law blogger yourself. Any thoughts on the White House dipping its toe in that pool?
I don't know. I got banned from visiting it because I accidentally went to whitehouse.com, so they shut it down here at work.
Does that still exist?
I don't know.
No, the guy had kids, and he decided he was going to stop doing it. He realized the error of his ways, actually.
Oh, well, yeah, then I'm all over it. Sure. I'll be
All right, folks. Well, it's been a great show. We've gone rather long, but I think it's been really, really interesting. Thanks so much for bringing us up to speed in a straightforward way on some complicated issues. Michael Weinberg from Public Knowledge. Great to have you on the show.
Thank you for having me. It was a lot of fun.
Folks can follow Michael on Twitter. You're MWeinbergPK. Is that right?
That's right. Yep.
All right, at MWeinbergPK. And Sherwin, too. Sherwin, great to have you on. And thanks so much for your insights on ACTA and the other things you're working on.
Thanks. Happy to be here. And I jumped onto the IRC chat, the Internet Relay IRC chat a little while ago. And I certainly don't mind people using my name. I was just a little wigged out by it. It's
Our chat room is the most delightful part of our show as far as I'm concerned. So don't be concerned. Just a little back channel there.
I'm just more used to being, called Sherman or Sherwood, or once in middle school, Shirley. So
Surely you just. Well, thank you so much. for coming on the show. Someone in the chat room is telling me Turkowitz is not the White House blogger. That was an April Fool's joke. I don't know that that's true because I saw it reported in so many different places. I'd be surprised about that. But hey, someone correct me if we're wrong about that. And I've certainly seen, I think, allusion to it from Mr. Turkowitz himself. So we'll see. Anyway, Evan, great to. Oh, I'm sorry. I meant to say folks can also follow Sherwin on Twitter, SherwinPK, at SherwinPK on Twitter. So you'll have
and
to start.
And also Public Knowledge at Public Knowledge if you're interested in the not just hearing our musings.
Absolutely. And tons and tons of, as Evan said, great resources, a blog, wonderful video descriptions of complicated issues, all the points that Public Knowledge is working on. You know, there are some great advocacy and information groups out there. The Electronic Privacy Information Center comes to mind. EFF comes to mind. Public Knowledge is certainly one of them, and we really appreciate their work. So thanks, guys, for everything you do.
Thank you.
And Evan, thank you for everything you do and for being back on the show.
Hey, it's good to be here. You know, those guys from Public Knowledge are pretty smart, aren't they?
They are. They are. What great jobs they both managed to land out of law school, huh?
Right. Yeah, this was a really interesting conversation. I enjoyed it a lot. So thanks for inviting me to be a part of it.
Oh, wow. So, no, I'm getting Turkowitz did this as an April Fool's joke. The New York Times got fooled. Apparently, we got fooled. Lots of people got fooled because, here's something about that White House blog post from yesterday. NYT gets punked. Oh, well, so did we. Good on you, Eric, for pulling one over on all of us. And I guess we're a little late. It's April 30th. We're still falling for an April Fool's joke.
Right. It's a good thing we saved it to the end, you know.
Yes. Thank you, Web 1842, for keeping us on the straight and narrow here. Folks can follow Evan on Twitter, Internet Cases, at Internet Cases on Twitter, and internetcases.com is his excellent blog where you can read about the kinds of things we talk about here on TWiL and all sorts of other interesting stuff. So thanks so much, Evan.
Thank you.
This is it for TWiL. We will see you next week for TWiL 59, and thanks so much for a fun show.
See you later.
Okay.
Thank you.
Bye-bye.